Just realized I look striped in this light. I may move.
You look like you have a band of light and then a band of dark. Okay, great. Well, thanks for starting the recording, Todd, and everybody. Welcome to the PRAC Legislative Subcommittee meeting on October 7th, 2022. Our agenda is pretty basic. I don't actually have it in front of me, but I will pull it up right now just so to share with anybody who can't see the actual thing, but basically just to talk through the drafts that Todd prepared on potential legislation, and we'll have a public comment period as well. Anybody want to add anything to the agenda? No. Okay, great. So let's see. What I wanted to start by doing was asking Todd to flag up anything that that you wanted to point out that you thought was particularly important for people to understand in the drafts that you put together. And I also wanted Steve, who doesn't seem to be here yet, to talk about any places the much shorter proposed language he put together differs from Todd's. So I don't know, Todd, if you've reviewed Steve's enough to be able to take a whack at that, or we can wait till Steve shows up. And then I wanted to go through just to see who's got questions and comments and see if we can make some progress on, understanding how we think this might fly. So Todd, why don't you take it away? First of all, if you want to just point out anything you think is, did everybody have a chance to read the draft legislation?
Yeah.
Okay, if you didn't, do you have copies in front of you, people? They were on the website, they're posted on the website, and I think you should have gotten an email as well. Okay, great. Yeah, Todd, do you want to point us to anything you think is a particular note? I don't know if you feel prepared to talk about differences between your and Steve's drafts. I have some notes on that, but why don't you go ahead?
Sure, thanks, Emily. I'm just going to say Steve emailed because he's having trouble getting into the meeting. I resent the link, so hopefully it'll work. He's had this issue in the past, and when I emailed him the link, it worked. So hopefully we'll be seeing him momentarily.
Todd, I'm on the phone.
Oh, good.
It doesn't work, I'm afraid.
I'm sorry.
I'm phoning in instead. So, yeah. That's
okay.
Right.
I don't know, Steve, were you here when I said one of the first things I wanted to ask you and Todd to do was just to talk briefly about?
Yeah.
Okay, so great. We'll call on you next then. Okay, so Todd, you want to go ahead?
Okay, and I'm sorry if I don't make this particularly succinct or concise, but I will try. So obviously, the goal was to incorporate our discussion of this expanded public interest category for offering either mandatory or discretionary fee waivers and reductions to different types of requesters. The meeting video wasn't rendered and I don't have the transcript yet, so I mostly went off my notes and memory. And so, for instance, I didn't recall that when it came to news media requesters that we were settled on shall waive and not shall waive or substantially reduced, which is why I left it as both in that draft. And you guys can help me, or we could just go ahead and vote if we wanted to use this language and pick the direction we're going in. But the whole point, and then I did have this notion of, well, if I'm already updating the statutory language, why don't I try to take a stab at adding in the other stuff that we seem to have mostly agreed on, or at least were areas that we said we're going to continue working. And then coincidentally, Emily, you asked me to do that. And so that was in line with what I was already attempting to do. Of course, none of this is set in stone, and I think most of it comes from our general areas of agreement, and of course, some of it's filtered through my own perception of those events. To get helpful language, I did a lot of online searching, and when it comes to things like indigency, I did find that 5 states plus the federal PACER system for court documents have some notion of offering fee waivers or discounts for indigency. 4 out of those 5 states have no test or definition of indigency. Michigan requires an affidavit. The PACER system, it's a case-by-case sort of fact-based analysis. Given that we were introducing or thinking about introduce this into Oregon, I created a much more narrow instance when indigency should be taken into account, and it's coupled with affecting a legal right. And so to try to back up and then encompass what I just said, you'll see that there's a very much expanded definition section of the public records law, which tries to flesh out what some of these terms mean. I think more guidance in the law that still gives public bodies flexibility is the best way to go, and that's what this version is trying to do. And so when it comes to the expanded public records or public interest section, you'll see that for all 4 categories that we more or less agree to, it is now shall language, but it shall waive or substantially reduce, and there's caveats when public bodies can't. And that's just my version of what we talked about. And the reason I want, or I'm going to suggest we stick with shall language, is that if we're really trying to move the needle here and make change, I think we have to implement this idea that when in the public interest category, no matter how large or small it is, this is when public bodies should be working very hard to reduce or eliminate fees, and that if they're not going to, they're going to need to tell the requester why. And that also starts creating a level of data and tracking that doesn't currently exist, but hopefully might in the future, either through statutory changes that we initiate or just through using better technology systems that allow for this kind of tracking. So that's sort of like the big picture. And then I'm happy to kind of talk these through one by one if you want. But a lot of the language I use comes from our own public records law or other states, because if it seemed to work and seemed to be spelled out in a concise way, I figured why not give it a chance here as well, at least as a starting point. And I liked what Steve did. I just felt like we were trying to go even further. So my version is more expansive than Steve's, although Steve's, of course, and he could speak to that, has shall waive for those who fit the FOIA definition of media, or in our case, my draft, the slightly modified FOIA definition of media.
Okay, great. Thanks, Todd. Yes, Steve, do you want to pick up on that and just explain how what any substantial differences between your suggested language and Todd's approach? His language is definitely a little more legally.
Yeah.
Go ahead.
Yeah, I don't claim to be an attorney. I think so. The big difference is simply inform. Mine is just discussing the public interest test and doesn't get into some of the other things that we've talked about in including in your proposal, Emily. So I'll just focus on the public interest differences. I think honestly, Todd's probably accomplishes a lot of the things that I was setting out to say. I think my prime interest is in that if we once we've established shall unless, that the size of a reduction, the presumption is that it's going to be a substantial reduction. If you've established this public interest, then that means it's something that's of a priority, that the legislature has defined as a priority to the public, and therefore we are going to have a public body assume the costs of delivering that. And then to the degree that there is a disruption, there needs to be a balancing, like if it's going to be such a severe disruption to public services that there needs to be a balancing, then there has to be some way at the stage of appeal for a third party to assess the validity of that balancing act. And I think it's possible that Todd's accomplishes that the way I had intended. As he said, mine says shall unless, and says if the public body is able to establish that there is this compelling counterbalancing interest, then they may partially or completely limit the amount of the fee waiver. And then it further says, when it comes to, I think another big difference is that when it comes to requesters, individual requesters, and requesters who are indigent, my proposal says may waive, and Todd has a shall again for that with the same kind of balancing test. I'm honestly somewhat agnostic on that point, and so that's not a major issue. And then lastly, I did provide some examples of things that would be in the public interest that differ slightly from Todd's, and I think either one could work. I really would be interested to hear what others say. I had, things that could be considered, shall be considered in the public interest include, but are not limited to those that may hold a public body accountable for wise spending or policy decisions, shed substantial light on the performance of a public official's duties, reveal trends and emerging problems and issues of public health and public safety, expose harm to people whose welfare is the public's responsibility, public body's responsibility. These are sort of the things that I think about as a journalist. These are things that we consider compelling and worth going after. And so that's one way of judging whether something's in the public interest. They're a little more specific than Todd's, but I think Todd's covers the bases as well.
Yeah, and if I could just follow up with a couple things I thought of.
Yeah.
Well, actually, yeah, I liked Steve's public interest definitions, but Steve, actually, my concern was if they were too specific, it wouldn't give enough guidance to public bodies. And if they had stuff outside those areas, maybe that, they would lean on not releasing it. But I did like what you have. Steve pointed out that I might have I might have the wrong version of a word in there a few times. And also, I think I have, like it says media where it should says public bodies. So there's a few things that need to be cleaned up as we go through this. And finally, you'll note that when it comes to, and we could go over this like line by line if you want, but when it comes to the balancing test that a public body has to undertake to decide whether or not it can release records even when there is a public interest, you'll see that it's a fairly involved test that the public body has to undertake to say, no, we're still not going to waive or substantially reduce fees, even though we found a public interest. And the reason I think that's important is much like some of these privacy exemptions that exist in the public records law, they don't stop at would releasing this information, like, in any way inconvenience or otherwise reveal private information. It has to then also become some sort of detriment to the person whose information is being released. And so I feel like if a public body has determined that this request is in the public interest, it merely impacting their other services, while important and needs to be taken into account, shouldn't be the final determinant that they can't still waive or substantially reduce fees. It needs to go that additional step of having this, really big impact on their services. And so I feel like, having a more complex balancing test is important, because all of us have probably seen public bodies that have merely said, oh, this is just taken away from our everyday work, and therefore, we're not offering a fee waiver or reduction. And I think when they have already decided it's in the public interest, they should have to go a little further before not waiving or substantially reducing fees. So I just want to put that out there. And again, we could talk about it as we go through individual sections.
So just to clarify, you're referring to the substantially prejudices or prevents the carrying out of the functions of the public body as the sort of involved depth of the public interest test, that language?
Yes, sorry, yes.
Wait, is that? I thought that was Steve's language, and you're saying you like yours better than that because it's more involved. Maybe.
I like my more involved test. I think if a public body has already found that there's a public interest, but is still not trying to waive or reduce or substantially reduce fees, they should have to do this more detailed analysis as to why.
The difference in language, if I've got it right, is Todd's version is substantially providing the records at no or substantially reduced costs. This is when after you've determined the public interest, it would substantially prejudice or prevent the carrying out of the functions of the public bodies, so long as the public interest in the efficient functioning of the public body clearly outweighs the public interest in disclosure. And Steve's language is, if the public interest is partially or entirely outweighed by a severe impact on public services that will be created by preparing the records for the requester. Right? Those are the two.
Yes, I feel like my test introduces this additional element beyond just a severe impact. It's a severe impact, and that impact outweighs the public interest impact of releasing these records. So in other words, yes, we acknowledge that this can have an impact on your operations, but is it enough to overcome the important public interest of releasing these records at little or no cost?
Okay, and just for
Okay, thank you guys. I feel like that was I wasn't following, but you got me on the page now. Appreciate it.
Okay, yeah, it's on page 4. What is it? It's like 5 capital B, 5 small a capital B on Todd's version, and on Steve's version, it's just the first A section.
And you're right about the legalese, Emily. You know, I was trying to do a balancing of clear and concise, but also what might pass muster as statutory language, which again, I know is entirely up to Leg Council, but I was trying to take a stab at it.
Yeah, no, and you should. I'm always like, what does that mean? But yeah, I'm also not a lawyer. Okay, well, let's open it up. Who's got questions? Who's got thoughts? Tyler.
Well, thanks. I'll jump right in. This is exciting because I feel like this is we're trying to have a deadline in October. We're in it. So I'm going to do everybody the kindness of I was able to run this by my members, run it by a few folks. So I'm just going to give you unfiltered comments in hopes that we can meet our deadline. So please receive it in that spirit. And I want to preface this with, I think, like, when I read through this marked up version, there's like 80% of it that I really, really enjoy, and 20% of it that I have concerns about. So keep that framing in mind. So
I like that ratio.
Yeah, I think that's a good ratio. That means we're making meaningful progress, I hope. From talking to a few folks, I think that the number one prevailing concern that I have heard from the county side folks who I talk to is still this media automatic waiver. And I think that as I'm looking through this proposed language, to me, that feels like the one piece of this puzzle where we are talking about an automatic waiver or reduction based on who somebody is, not based on necessarily that what of does this meet a public interest test. And the specific place that I want to point to, so on page 4, let's see, 5, sub A, sub B. So there's this last bit I'm reading. So if a public body makes such a determination, and that determination is that that the person requesting is in fact a member of the news media. If the public body makes a determination that the requester is a member of the news media, the public body shall furnish the records at a reduced fee that balances public interest and disclosure against the impact on public services. There's some unfunded mandate type costs that are included with that. Number one is who on the public body, what's the administrative burden of the person who has to do the balancing test? Number two is, regardless of how that balancing test shakes out, if there is a shall go in at a waiver or a reduced rate, that is an unfunded mandate that comes in. And so I like the idea. When I was comparing these side by side, I saw Steve's absolutely put more discretion, I think, in the hands of the body. It said that I think it said that it's up to the public body to determine that interest test, and then there was no accompanying shall waive after balancing. So I throw that out there again in the spirit of just telling you what I am hearing from folks. I think that from some of the county council type folks who have taken a look at this, they're very concerned about the breadth of the public interest exemption. They're worried that this would represent in many ways an unfunded mandate. But the thing that I think would help is if we could pull out that specific line about if we determine that somebody's a member of the news media, then we shall waive or reduce. So I want to be clear. I don't disagree that somebody practicing their profession as a journalist doesn't meet the public interest test. I just don't know if the litmus for that should be the fact that they are a public journalist. I think that it should be about the actual action that they are performing.
Okay.
I'll pause there.
Okay, Michael, you had your hand up.
I need to unmute myself. Sorry, guys. So I have a little bit of reaction to what Tyler just said, but before I get to that, I think my sort of initial framing comment, because we're working on these two in many ways very different drafts at the same time, which is obviously kind of difficult. What I really like about Steve's draft is a couple of things. One is I feel like where Todd did, as you asked him to, Emily, include a bunch of things that we haven't really resolved yet. and that we've talked about putting off for future conversations. Steve's is nice because it really is all focused on the nub of what I think we're trying to do. So it feels easier for me to talk about Steve's just because it is more narrow. I also think that the examples Steve gives of public interests, although I don't know that they ought to be exclusive, they feel like the specificity of them feels very helpful to me. Like they're very specific, and yeah, I think Todd is right that maybe we don't want to be strictly limiting to that, but I think that kind of specificity in a statute is nevertheless a really useful kind of illustration in a list of examples. So I like those things a lot about what Steve did, the sort of focus of it and the public interest test. I think there are some good ideas in Todd's that I would like to see sort of refined into a similarly digestible package so that I feel a little more comfortable that we can talk about this one idea at a time. And I know that it's a little late to be saying that now, and that was specifically not his brief when he got his brief. But I don't know. I guess I have a harder time talking about Todd's without going into like some questions about other things that are still in there that I don't feel like we've necessarily sorted out. On the sort of public interest test, I think where I end up really is I think I'm okay with either one of them. And to me, what I really, if maybe there's a path towards agreement here between all sides, what I think we're really shooting for is a system that allows the sort of public costs to be allocated by someone who's like responsible for that decision and is considering the interest in transparency and like taking them into account seriously. And I think both, honestly, that both of their languages sort of get at this sort of sometimes competition, right, between the need of the public body to do its job and the need of the public body to do its job transparently. So I don't know that I have a strong preference really with respect to the language around public interest, but I just feel like Steve's is easier for me to talk about because it's limited to that. Tyler, you mentioned unfunded mandate and the sort of administrative costs of making these decisions. I guess my reaction to that would be the current law functionally does require these decisions to be made. It then creates discretion in the public body whether to do anything about them, but I don't think there's a new requirement here in terms of the decision-making process. And I just wanted to kind of push back a little on the idea that's new.
Okay, great.
Yeah, and if I can just respond briefly, I'll just say, I wouldn't be doing my job if I didn't share the comments that I had received, and that was one of the comments I received. And I do think I largely agree with you, Michael. I think that the larger thing for me is that you could have a case where we acknowledge, yes, this is in the public interest. However, there are other things out there that are more pressing in the public interest right now. I'm thinking back to the idea of, records requests versus running an election that we talked about out last week. So you can have an acknowledgement that both of those things are in the public interest, that one might come at the detriment of the other, and yet there is still a requirement with the language that we have now that a waiver or reduction be granted.
Steve, you had your hand up and you took it back down. Did you want to join this?
Well, I think it would be good to hear from others as well, but I did have a clarifying question for Tyler. So when you're talking about the shall language that's of concern, it appears two places in Todd's. It's in 5A and then again in 5 capital B. Which one of those is one of your members were concerned about?
Well, I'm looking at the capital B one, because under the sub A, that's where it says the shall unless.
Mm-hmm.
And so there's like a shall unless within a shall unless when you get down to the B. And the B is what concerns me, because I think A is what we've been talking about. It's you shall unless, but then that's the end of the discussion. You get down to another layer of it, and it doesn't matter if you've determined it falls on the wrong side of the balancing test for your public body. You still are going to be required to either waive or substantially reduce.
Yeah, okay, that helps. Although arguably, you could read that to mean, okay, we're going to reduce it by, 0.1%, because that's the appropriate balancing test.
I think that's a question too about what do we mean by substantial, which is scary.
Yeah, I just to tag on that, I do think there are some subjective words in there that really could cause some challenges. Substantially is fraught throughout, and I do have a little bit of a concern with that. But again, I'm enjoying this conversation, so please continue and don't let me mess it up.
Todd, go ahead.
Well, I just wanted to point out, as I said in the notes, substantial is already part of the standard in the statutes. That's why I was trying to not change some of the basic requirements and really beef up understanding and enforcement and provide some consequences for not doing it. But given everything we've heard, that you've expressed your members' concerns, what we've heard from those who have testified, and the understanding that, like, for instance, using the FOIA tiers was perhaps a bridge too far for our first go at this, I tried to keep that in mind when drafting this, and that's why I didn't really deviate from the existing standards. I just tried to make them clearer and more enforceable. So to the extent that that word concerns you, just like FYI, it's already there. And so maybe we need to define substantial as what, 50% or more, or just, I'm just throwing that out there, obviously. Maybe we need to give a little more meaning to what substantial is then, if we're going to keep it and base any changes off of that.
Michael, can I ask you, since you were, identified Steve's as narrowing in on sort of the real heart of what we're trying to get to here, are there pieces? I mean, they're all interrelated, it seems to me. So I was just curious, are there pieces in, just to sort of help further direct the conversation, are there pieces in the draft that Todd put together where you feel like this isn't something we have come to substantial agreement on?
Well, I guess I don't really remember very well that we were agreed on the utility of like delineating how much is review, how much is search, and how much is reproduction costs, for example, and the utility of that in every case. I don't remember that we really reached any sort of decision about addressing metadata in what we're gonna do. I mean, and then there are things like even just kind of the description of the different types of costs that are permissible, where, I mean, it may or may not be harmless, but I feel like both Steve and I expressed the idea that if we were going to tie that to something, it might make sense. But I feel like in this draft, it's not actually tied to the change we're proposing in terms of fees, which is really all about this move from may to shall. So I mean, I'm not sure that we ever resolved those issues, and I'm not saying that I would necessarily oppose a version ultimately that included them. I just feel like all those are things that are kind of not the nub of what we're talking about, which makes Steve's easier to talk about for me.
Got it. Yeah, I mean, I mean, that is the very substantial heart of things that, may or shall in the public interest. So Tyler, one thing you brought up is this, who is making a request rather than what the request is. So it sounds like, if I'm understanding right, you're uncomfortable with the idea that a news media request is in the public interest.
No, I wouldn't say. I mean, as we've talked about in this context, right, I personally, and I'll speak only for myself here, right, I think I would agree that when somebody, a journalist makes a request, that seems to meet a public interest test. What I'm uncomfortable with would be in the statute tying that simply to who that person is, who they're employed by. We've talked about trying to be agnostic in the spirit of transparency. It shouldn't really matter who the request is coming from. What should matter is the request in the public interest or not? So I don't like a carve out for one specific group just based on, where they happen to be employed, getting an automatic exemption. And I think, so yeah, I think what I would like to see is more that we are blind to who the request comes from, and instead just focus on, does this meet the criteria for a public interest test? I imagine that pretty much any public records request coming from a journalist would satisfy that public interest test, even without calling out specifically, it's because I'm a journalist that I get the exemption or waiver.
I thought that, oh, and I probably shouldn't just jump in.
Jump in.
I thought that Todd actually did sort of require that the journalist request be in the public interest in small a on page 4. Todd, maybe you want to talk more about that, or maybe I'm just was kind of misunderstanding. Sorry, capital A gives the ability of a public body to sort of conclude that even though it's a journalist, it's not in the public interest, which is kind of what I thought we had agreed to as our framework.
Steve's
Me
language
too.
says a request in a news media representative shall be assumed to be in the public interest unless the public body demonstrates that in that particular instance it's not. So it's demonstrating that it's not in the public interest rather than determining, like, the default is it is, and unless the public agency can demonstrate that it's not.
Emily,
I just want to check with Tyler. Is that so? I want to clarify, which language are you more comfortable with?
Yeah, I liked Steve's more in this case. Steve's was talking about, essentially what we talked about was just the shift on the burden, right? A public body should tell you why they are denying your request. What Steve's doesn't have any language about it of, once that determination's been made, there's no weighing test and determining of fees against that weighing test. Steve's just says they have to tell you why they're denying your waiver. Whereas this 5 capital B on Todd's draft says that even after you've done that weighing, then you have to come up with a waiver or reduction based upon that weighing.
Todd, I think I cut you off. Were you gonna?
Well, I was reacting to what Michael said, but also maybe in support of what we're discussing now. Yeah, it's this. I was trying to address Emily Gothard's concerns that everyone else seemed to agree with. Well, what if they're media, but it's not in the public interest? So that's where Steve and I both have this, that if it's a news media requester, they're presumptively in the public interest unless there's a reason to think they're not. And mine, I wanted to give a purposeful example, like for commercial use, so people could understand if a member of the media is writing their own book or something, then that doesn't necessarily qualify under the definition. But just to be clear, the FOIA definition itself doesn't just talk about a person working at a news media organization. It also includes that they are attempting to disseminate, I just want to find the words real fast, news, which means information that is about current events or that would be of current interest to the public. So again, there is still this specificity to it that would, I think, help clarify who's getting these records and why. And so, Tyler, I don't think the point of that section of the expanded public interest is really about who. It's still about the what, because they are work in a specific environment, but they're still bringing forth news. And to the extent that it's concerning to your members, I think a deeper parsing of this language might help them understand that this isn't just like still a giveaway to the media, that there's still like really detailed steps that have to be taken. And yeah, the ability to say no in mine is more detailed and complex, because I think personally we're high past the time where we sort of rely on public bodies to do their own full top to bottom interpretation, because I'm seeing many instances of where that doesn't work out and members of the media are not presumptively being considered for fee waivers and reductions, even when they're clearly who they are, because the public body feels so overwhelmed by these requests, or the amount of work that goes into it, or in some cases that are in the news, are a bit hostile towards the media. And so I am in favor of a push towards making this a bit more mandatory, even though I realize that probably represents a bigger uphill battle in the building when trying to get some results here. But I mean, what are we trying to change if we're not actually trying to change stuff?
Okay, thank you, Steve.
Yeah, I like that that phrasing. I think what I'm hearing Tyler say, because when I look at Todd's and my provision on news media, I think substantively it has the same effect, but it's really maybe it's a question of tone. In Todd's, he's saying, if you are news media, this is how we will deal with you, and how we will deal with you is we'll you get the records for free or substantially reduced unless XYZ. And mine, I say, if it's in the public interest, you'll get it for free. And by the way, public interest means news media unless it's not. I mean, there's just a shift in how it's expressed. I think if it's more comfortable defining news media as kind of de facto public interest, I think sort of people's comfort level, including Tyler's members, probably matters.
And Tyler?
I'll just do 2 quick points, and then I'll turn it over to some other folks who I feel like I've talked a lot in this meeting. I think, so first is a strategic consideration, right? We talked a lot about over the course of this process about trying to keep a fiscal off of this thing. If there is, in fact, and the way that a fiscal would work is that once this bill language, comes out, it gets pushed out to all affected bodies, local governments get their own, review of it. So that would come to somebody like me. I farm it out to my members and I say, what's this going to cost you to comply? If there is an automatic waiver in there, regardless of whether or not we think that's appropriate, if it is a change from current practice and it comes with an associated fiscal impact, this bill will have a huge fiscal on it. If it comes to local government, state government, if there is a shift where you are now required to, offer a service for free that you were previously able to recoup the cost for, that will have a fiscal impact on it. So I want to just flag that. I think the other piece, I agree with the sentiment shared that if we're not trying to change something, then what are we doing here? I think that this gets to my, first comment that there's like 80% here that I'm in favor of. I think that if, at a minimum, our incremental baby step, if we can increase the shared nomenclature between bodies and requesters, that will meaningfully move the needle towards lowering fees. And that's my sentiment. Others may feel the same way, but I think in the spirit of trying to, drive a consensus around this, I think that that's something we might all be able to agree on, even if we disagree on going further than that.
Can I clarify, Tyler? So when you look at Steve's shall unless, which was more comfortable than the shall unless, if I can paraphrase. So this says, if the custodian of a public record determines that disclosure is in the public interest, because making the record available primarily benefits the general public, the custodian shall furnish copies to the requester without charge. And then it goes on to say how the custodian of the public record may limit the portion of the fees if it's determined in that particular interest. In that particular instance, the public interest in disclosure is outweighed by a severe impact on public services. So when your members look at that, what do you expect them to say about the fiscal impact on them?
It's a good question. I mean, it's going to depend county to county, right? Because every single county council is going to take a different look at that and interpret it differently. I can tell you what my interpretation of that might be and what I might be walking through my members of that might be. What I see here is that Steve's language, as I read the two with a non-attorney brain, so please forgive me for that. But I read that there is more discretion in Steve's, because Steve says that it's basically up to the public body, and if they say under Steve's, small a here, that if the public body determines that there's going to be a severe impact on delivery of public services, they can say no, and that's where it ends. I understand how that could be, misused. I do, but I think that is a step in the right direction, because it does still represent that shift in burden from requester to body. Steve's language still requires a body to tell you why something doesn't meet the public interest. That's how I read the two of these.
Okay, so but it says the custodian may limit the portion of fees. The portion of fees. So it doesn't read to me like you can just say, if the public body can determine that it's going to it's going to have a severe impact on public services. So there's room in there to not just say, no, this is not, right? There's room in there to say we can partially waive this or something like that as well, right? Is that the way you're understanding it?
That's
Yeah,
correct.
I mean, limit can be anything from 99% down to 0.
Okay, sorry, I was hearing you say different things than I understood it to read. So that's helpful. Let's see, is there a hand up someplace? Sorry, Mark.
Sorry, having trouble with my mute button. I apologize. I really want to I'm having some tensions here personally, all right? And I'm sharing my personal tension here. I agree that it's not, that if we're going to do change, let's do change, right? But at the same time, folks, I want to be really cognizant of the fact that the more change we create, the steeper the hill it will be to get something passed. And I don't want to lose sight of that, because we're doing a lot of good work here. And I would hate for us to do a lot of work to be summarily dismissed by a lot of the big stakeholders that are out there watching this, okay? Every legislator, I'm just going to say this, every legislator has a county, every legislator has a school district, every legislator has a special district, not entirely true on that, and every legislator has a city, okay? I can tell you they are going to hear about this one way or the other from their constituents, and that's going to weigh heavily on them. So having said that, there's a difficult balance here that I'm trying to hopefully reach, and most of my comments should be filtered through that lens from this point going forward, because now I think we're really getting into the heart of the matter. And I want to be really cognizant and really focused and clear-eyed about the fact that I'm already hearing from people that are really concerned about this proposal. All right. I'm just going to tell you straight up. I've heard from local government, not necessarily my members, who say they are going to oppose it. Okay. Having said that, I don't think that this work is for nothing. I think we're doing really, really important and good work here. And I'm with Tyler in that I'm comfortable with about 80% of this. But what we're going to get tripped up on is this very issue that Tyler is raising. And that is that, and here's the example, and this is where I'm really struggling. So forgive me, and I hope you'll indulge me, Madam Chair, but I'm thinking about a request by a member of the press that's going to cost a little old, let's just say, I don't know. Let's use a city because I don't represent them. Sorry, Scott. That is going to require some serious IT work to dig up emails from a certain individual that say costs about $22,000 to ultimately produce. And you're going to tell that local government that has a pretty small budget, general fund budget, that you're going to have to provide that those records at a cost of about $22,000, either for free or substantially reduced because it's in the public interest. Now, the challenge I have with that is they're the two competing goods here, right? There's the good of being transparent, and I think that that's our general goal. But I don't think we are necessarily wanting to place a local government into a position where they're having to make general fund decisions based on a couple of public records requests that have serious budget implications for them. Okay. This is the tension that I'm really struggling with internally. And how you solve that is going to matter, I think, a lot, or address that. So I don't know what the balance there is. I don't know what the answer is, but I'm just being completely open here about the struggle I think I'm having. I think Tyler is similarly struggling with, and perhaps Scott as well, is that, you know, we work for these local governments who have finite budgets, who are stretched, largely because of our property tax system, which I think ultimately is the boogeyman here, but we don't need to get into that. I don't know what the answer is to get everybody comfortable, but I want you to all be aware of the fact that unless we find that balance, we're going to have a hell of a time getting something through the legislature. And I just want to point that out as a sort of a reality check, that appetites may be large, but be careful how much you try to put on the plate, because it might sink the table, so to speak. And that's just the caution that I want to throw out there and share with you the struggle I'm having with this. Thank you.
There's other people who've got their hands raised, but Mark, I do have a question from you, and thanks for, you've been clear for years now about your interest in supporting change, and I appreciate the fact that you are frank in your struggle. The $22,000 example that you gave, do you think that would not be taken care of under this, and I'm looking in Steve's version now, number D, if the custodian of a public record determines that a request is not in the public interest, or that the public interest is partially or entirely outweighed by a severe impact on public services? I mean, it seems like that language, and forgive me if I'm misunderstanding it, it is designed to specifically avoid the forcing, if you will, of an agency to make general fund decisions because of a single public record request. I mean, that language seems designed to take care of that. So I'm curious if you could just elaborate on why it doesn't, or how you hear that when you're looking at a potential, $22,000 charge that might affect some other services the agency does.
Forgive me, Emily. I'm reviewing B again here. I think the first part of the sentence, or that the public interest is partially or entirely outweighed by a severe impact. Again, severe, in my view, is in the eye of the beholder. That I don't have not going to get into the word smithing here. That may be sufficient. I suppose I'd want to consult with a few other individuals. I will confess, to some extent, I do like Steve's sort of shortened approach, in that it's about 2 pages rather than 8. That makes things a lot more simple, at least for a simpleton like me. I did have some questions about Todd's proposal. Emily, I guess I don't really have an answer whether that's sufficient or not. I suppose I'd want to consult with a few people who are have more clear and objective minds than mine.
Thanks, and thanks everybody for indulging me in that question. Oh, there were a whole bunch of hands up and now they're down, but let's go to Michael. I think you've had your hand up for a while.
Mine is still up. Yeah, no, I think I was going to point to the same language Chair, but I was also going to remind everyone that we heard over and over again that public bodies aren't collecting a ton of money from public interest requesters already, right? This is a change that's going to affect edge cases. And I mean, of course, it's possible for someone to come in and put a fiscal on everything, but I hope that your members and people who aren't your members and governments in general will have that in mind when they think about this. Like, are they really collecting so much revenue from people who are going to meet this public interest test that it would actually make the sky fall? I think it's funny, Mark, that you kind of landed where I did in terms of like comparing the two documents, and just one just feels so much easier to talk about. And it may be that we want to bring some of the ideas from the longer one into that, but I think while we're doing reality checks, I just wanted to offer the reality check that like there aren't a ton of fees being collected from public interest requesters now.
I see Alan Kessler, a member of the public, has his hand up. If you don't mind, Alan, I'll continue with the members of the committee for right now, but we will definitely have a public comment period and we'll welcome your testimony at that time. Scott?
Thank you, Chair. I don't mean to, I think Tyler's hand may have been up before me, but
It was, I'm sorry, but you haven't spoken yet. So
he's waving off. And I would just chime in to say, I apologize, I had to step out. It's homecoming day in Milwaukee and the high school marched by the City Hall and we have to make our appearance to cheer on the Mustangs. But I generally agree with what Mark and Tyler are saying. That's probably no surprise. There are concerns from cities, and I have too heard from people who are aware of it and have expressed concerns. But I also have to really underscore, I think we're really close to something here. There is language to be cleaned up. And frankly, as Mark was saying, I think the biggest hurdle is, and I appreciate Todd and the lawyers in the Legislative Council office who are going to do with this what they will. We have to make this in plain language. That is perhaps even more than half the battle. I think I've been in enough records management discussions over the years that by and large, cities and record custodians want to do right by the public. They want to do right by the local journalists. And if they can wrap their head around what they're asking us to do, I think providing the receipt for all these steps, like here's the reason why, and here's the ORS, they will, I think, easily conform to that, even with some apprehension. It's just getting to a point where we can clearly articulate what it is we're saying. And I then would echo what others have said, Steve's language, and I tracked it easier. A lot of the capital A's and little A's, which I know are not the fault of anyone here. That's how our statutes are written. That's not helpful. And that's how it's going to have to be ultimately, I'm sure. But the language is key here. I think it was going to be my big, I read it several times. And I appreciate hearing you all talk about it before I talked, because it clarified what it is I read. But again, I just echo and say I've heard the same thing from other cities, that there's concern about it, but they also are the same people who would very much welcome increased definition on news media. I've had to write a definition of news media for my city for an executive session policy, and it wasn't the easiest thing in the world. We got there, but having more clarity, I think, would be welcomed. It's just how we package this and how we speak it. So those are my thoughts. So thank you, Mark and Tyler and everyone. I'll say that I think this has been a really interesting and good conversation. So thank you all.
Okay, thanks, Scott. Tyler?
Yeah, just a note on fiscal impact. I mean, I agree. We've heard that largely public bodies, right, are, when possible, granting waivers to members of the news media. However, that does not apply across the state. So I'm thinking the fiscal impact writ large, yes, might be small if they're taking into consideration the waivers they already give. But you are going to have instances where specifically public bodies have a fixed constitutional, very bare bones property tax rate, where they might not be granting waivers to anybody. So for them, that individual fiscal impact might be huge. I also think that with the, currently, because it is all up to the public body how much they decide to waive or not, I think you're going to see, I mean, there's a lot of economic forecasts right now that we're teetering on the edge of a recession. So this might be an easy place. So yeah, we might be waiving, there might be a lot of waiving being done when times are good, but when times get really tight, this might be a place where public bodies say, you know what, we are allowed to recoup actual costs, and we've been happy to grant waivers in the past, but now that we have, you know, extreme needs, we're going to utilize the statutory authority that we have to actually recoup full actual costs. Is that fair? I'm not going to make a judgment on that of whipsawing your fee policy, but that's where it stands right now, and I do think that that will hold bearing on the fiscal impact of what we decide to do here.
Can I ask you, Tyler, the same question I asked Mark? Because Mark, I remember we were asking you if you had some examples of agencies. I can't remember the exact request yet, but you hadn't heard specifics on your agencies about getting like volunteers who got a lot of public records. I'm sorry, I can't remember what it was. It's about 4 meetings ago. But Tyler, can I ask you the same question? This, you know, theoretical, or like not necessarily theoretical, but an unidentified public body that may, you know, not grant any waivers right now and so be heavily impacted potentially by this change of language. Do you feel that this language in section D of Steve's proposal takes care of that? This, if it determines that the public interest is partially or entirely outweighed by a severe impact on public services, do you think that that would take care of that instance?
I do. However, I'm just going to say that when I mean, again, this is a non-attorney looking at this, right? And some of the feedback that I have received is that I think, right, out of an abundance of caution, I've imagined some county councils are looking at this and saying, well, this is too expansive, and this is to be safe and to protect the public body from liability that might be associated with this. This would, you know, functionally be a waiver or a substantial reduction. So I do think that some of, you know, if I get a fiscal impact request from the Legislative Fiscal Office and I ask my members, how much is this going to cost you? I think that from some of my members, I'm going to get substantially high figures.
Michael, thank you.
I just realized I left my hand up and was going to put it down, but I think I will say briefly, since I have the floor, that I feel like these sort of cautions about how people might react to what we're doing, sort of coupled with the fact that we have language that is meant to address these problems, really points to a kind of need for an educating effort on our part, and is not really a reason to sidetrack. I think what you're saying, I think, is that this shall and less language looks good, but we can't be assured of a smooth passage. It is subject to interpretation, and we need to be sort of proactively reaching out to people, talking about what we're doing and sort of building a coalition, which sounds all right to me, and also like move forward with that awareness.
Okay, thanks, Michael. Steve?
Yeah, following on that, I think Michael's right. And I think if I were writing talking points for this, I would say no automatic fee waivers. This is an approach that says these are the guidelines for what we think, we the legislature think, should constitute public interest and therefore should generate a fee waiver. But we've created all these outs for the public body to balance other interests. That's all.
Okay, Michael, your hand is still up. Is that a mistake? Okay. I'm taking those. I'm sensing a decent level of coalescing around the language in the document that Steve put forward, partially because of its narrowness, partially because of its language. I think a lot of the things in that are further detailed in Todd's, and frankly, a number of things that we have discussed that we haven't, either we have discussed and come to some consensus on, but not necessarily fully, or some things that it seems like there's consensus on, but we haven't actually discussed very, very much, but just in specificity we haven't discussed, but we've discussed in concept. But I'm feeling some coalescence around Steve's. And so I'm wondering if this would be an appropriate next step to take a vote on moving forward with this language in Steve's text as the basis for our legislation that we would propose, and then we can go back and look, even in this next half hour, if we want to take a vote on this, we could go back and look at some of the places where we got very close to agreement or just needed a tiny bit of clarification. Some of them are in Todd's proposal, some of them are not, and we could identify where we want to move forward to perhaps add on to this and revisit, as a package at our next meeting. Do people feel interested in that, Todd? Or sorry, Mark, I think you had your hand up first.
Yeah, thanks. I just wanted to, I personally am comfortable with that approach, Madam Chair. At the same time, I don't want to lose the work necessarily that Todd has put in. And so I do think that it's important that if we use Steve's draft as sort of the basis for moving forward, so long as there's assurance that we'll review the components contained in Todd's to ensure that either A, we've checked that box in Steve's draft, or if we haven't, or it hasn't been addressed in Steve's draft, forgive me, that we will take up those topics and dispose of them one way or another, because I still think that there's some interesting and potentially compelling things in Todd's that may not necessarily be in Steve's draft. That's the only request I would make, but I'd be comfortable with that approach. Thank you.
Okay, do you have, can you point to the things that you'd like to make, that you find compelling in Todd's? I agree completely that we should go back and revisit and check our boxes, but are there
Would you just stop putting me on the spot, will you, please?
Accountability, baby.
No, I'm not going to point to anything in specific right now, but I mean, talking about, for example, indigency versus records that, I think Steve's was largely pertaining to the individual. I have a problem with the largely. It should be just relating to the individual, because I don't want to get peripheral things mixed into that. So there's your example. I'm going to shut up now.
Thank you. That's really helpful. Thank you. I think Todd's hand was up next, and then Steve's, and then Tyler's. Is that I didn't see your all's hands go up, Steve. Sorry, Scott and Tyler. Is that right? Okay, Todd, can you go ahead?
Well, since I'm following the very thoughtful Mark Landauer, has already mostly said what I was going to say, but it's just that, first of all, I'm more than happy to work with the group and support whatever the majority thinks is the best way to represent public interest in news media. So I have no issue with that. And I do like a lot of what Steve wrote. My concern was I didn't want to leave behind concerns about indigency, individuals' records, et cetera. To the extent we're working on settling the language for public interest in news media, I'm all in favor of your proposal, Emily, with that caveat that we have these other categories to go back and address later.
Scott?
Tyler, I'm sorry. I think I'm jumping ahead of you once again. I apologize. But mine was basically process. I agree with the chair and the consensus that there seems to be favorability for the language proposed by Steve. I'm comfortable, I think, voting on a motion for accepting most of that, but I would like to have some sort of a mashup of the two so that we come out of the subcommittee work with a single thing that we're proposing. So that's my big yes yes and, but it's one of my problems is kind of whiplash going between these different versions and going like this. And since we're all kind of saying that, maybe we should, and I appreciate that perhaps means more work for Todd and Steve to work together or in some fashion put these things together. That was my request. And then process timeline. I know we're going to talk about that in a minute, but yeah, does this then, whatever this subcommittee wants to propose, it goes then back to the full council, yeah, and then to the legislative council. So there's at least one more meeting in the subcommittees. I know we have a whole schedule, and I know we're talking about that, but those are my questions.
Yeah, you're correct.
To be,
yeah, go ahead.
Sorry, Emily, just to be fair, would it be full council, Senator Thatcher, and then Ledge Council? Okay.
We're not submitting directly to Leg Council. Yeah. Thank you for that clarification. Tyler, and then I think Mark, you put your hand back up. So yeah, Tyler.
Oh, I just wanted to offer, I think there's 3 components that are in Todd's that are missing from Steve's that are worthy of consideration. One was indigency. 2 was clarification around recoverable costs. And 3 was, what about somebody's own records? And I'll put an asterisk on the own records one to just say that I got feedback on that as well. I mean, very specific feedback, like a lot of instruments recorded with county clerks. They might, the cost of compiling that might be less than the actual, I'm getting so mixed up here. The cost, we talked about waiving if the cost of compiling the record is less than the fee itself, right? But there are a number of instruments recorded with county clerks in particular that test might not work for them, and we wouldn't necessarily want to go after those revenue streams. Regardless, back to my greater point, there are 3 discrete pieces that I saw in Todd's that I don't want to lose sight of. So that I'll leave it there.
Yeah. Okay. Thanks. I think, and Todd's did actually address that. I think there's a piece.
Well, yeah, if I could just help clarify, it wasn't just compiling like the clerk's work or whomever and creating the record, it was also in recovering the fee. So the time it would take a, salaried staff member to then go out and collect that cost as well. So that would be added in. If that exceeds the fee for providing it, then it would be prohibited.
Let's get to that in a second, because I think everybody wants to discuss that. So Mark, on this, go ahead.
Slow microphone. Forgive me. I just want to I think everybody understands this, but I just want to be clear for the record that despite the fact that we're voting to sort of use Steve's model as the basis for our continued discussion, that Steve's draft is not in any way, shape, or way chiseled into granite. We're still working on that language, folks. For those of you out there in the public that are listening, this isn't necessarily an endorsement of that. It's just the model that we are using to go forward. I just wanted to be clear on that. Thank you.
Thanks, Mark. Michael?
Well, just on that note, I wonder if to the extent people feel like there are problems with the language or could be improvements with that language, maybe an expectation you want to set, Madam Chair, is that people provide specific changes to that language they would like to discuss in time for our next meeting. I'm pretty comfortable with the language. I heard concerns about how it might be interpreted, but it seems to me that largely the proposal at least attempts to address those, and if it is not doing so adequately, that the people who think that ought to tell us specifically how to make it better.
Okay, thanks, Michael. Tyler?
Oh, just an observation. I think sometimes, rather than offering armchair legalese, which we could do, getting in plain language what we want to be included here and getting that to LC, I mean, that's Legislative Council's job, is to then translate, what the policy direction we're trying to go into legalese. And it might be easier to get our plain language version here, have some agreement behind it, send it off and see what comes back, rather than trying to wordsmith it, because they're going to wordsmith it no matter what. So let's give ourselves the gift of time and being able to react to what LC comes up with, rather than us trying to do that work.
So when you look at this language in Steve's proposal, I mean, are you saying, Tyler, sorry, forgive me if I don't quite understand, are you saying that you're comfortable with this language, plain language as it is, or there's some changes you would prefer to make to clarify the plain language before we sent it to Legislative Council? Just addressing the issue Mark raised of, whether this is wording that we would be comfortable forwarding, or whether this is not yet wording that we would be comfortable forwarding.
I'll say that I think most of the reaction that I got from circulating this was, I think, to Todd's proposal, because it was, I mean, I got very like nitpicky feedback about, not nitpicky, substantial feedback, right? But about, well, if this language is in this RORS, this means this. And again, I'm not an attorney, so I'm going to leave that to, when I get that sort of feedback, that's what I want to pass along. So I think with that in mind, if this is the direction we want to go, and I am hearing kind of somewhat of a consensus that it is, I would like to have the chance then to circulate Steve's draft again to my membership and those people I work with and say, here's the plain language version of where we're going, what needs added in plain language, so that then we can incorporate that and send it to LC. So that's sort of I think yes to both sides of your question there. I am comfortable with this. I just also want to make sure that my members have a chance to know that this is sort of the framework we're using now, and give them a chance to give me some feedback on it.
So before we figure out what steps to take, because I do think it's important to provide language in enough time that people can get reaction and come back with specifics. Todd, can you remind me, and I should be able to do this myself, but I don't have it right in front of me, and if you don't either, I'll look it up, but what, and also just, we're going to get to the public commentary in just 1 minute. What are our next scheduled meeting dates?
Take a look right now. October 14th and 28th, although we were thinking that might be the full council if we had a legislative concept ready to go by then.
So yeah, October 14th is in a week.
Yes.
And even if we got, so what we're talking about is potentially coming back with specific language changes to Steve's, but we also need to revisit a number of points that were raised not only in the proposal that Todd put together, but also just in our conversations over the past number of months. Let me think on this for a second while we take some public testimony. Oh, Steve, did you want to speak, Steve?
I just want, so if I understand right, we don't have another meeting for 2 weeks.
Well, the October 14th, which I actually will be on an airplane.
Oh, okay, never mind.
So Todd will be chairing that, but and then the 28th is what's scheduled right now. There is 1 week in between. Obviously, we could schedule another one.
Yeah,
we can fit that into our calendars.
That was going to be my question: is are we close enough that we should try and book another meeting, say the 21st ish?
Okay, let's everybody think about that and think about your calendars while we turn to public testimony for a minute. I think let's see, Alan Kessler, you had your hand up earlier. Do you want to speak? And if there's anybody else who wants to give public testimony, if you could put your hand up now, that would be great. And if you're on the phone, prepare to speak up in a minute. But Alan, did you want to go ahead?
Oh yes, please. Thank you. It strikes me that this conversation is talking about cities that are as small as, a drainage district, or as big as a city. And there was an exemption that was added to the 15-day requirement from 2017 that was supposed to be a carve out in legislature record. It's supposed to be a carve out for small cities. The Portland Police Bureau now says that they take 12 weeks to respond to any request, and they're citing that exemption. Like, it wasn't meant to, and they've been doing that. It was 6 weeks before COVID. They've had many budget cycles, they haven't fixed it. That's not what it's supposed to be. I feel like there should be a way to distinguish between a small city who really will have effects of a $20,000 request from an IT department, although I have qualms as to whether or not they're doing it right if it costs $22,000 to search for emails. One way to fix that might be to have a safety valve that involves either the public records advocate or the archivist, and allow bodies to just throw up their hands and say, Mr. Albert or archivist, if you want to take over this records response, I'll let you. And it can all be permissive, but there may be a body that could then do the collection, do the distribution. And maybe there are substantial records that are useful in these small districts that we just couldn't get at, and it would disrupt their process too much, but they're librarians who could probably handle doing collection, doing review, making the records available as a permissive step rather than tell the requester, no, this is too expensive.
You mean, so basically pulling resources from other public bodies to.
Yeah, allowing, and you could do it as a permissive step. So you could give the director of the PRA the discretion whether or not this is an important use of our funds, and we're going to supervise this request because it would only cost $5,000, but that would not be feasible for this tiny little public body. Another way to do this would be to have a means test. So don't allow public records requests to exceed a certain percentage of the general budget, probably a fractional percentage, or limit this exemption to public bodies that are smaller than a certain size. Because I think at a certain bulk, like if you're the city of Portland, you should just answer your public records request. You've got $1 billion budget, you can fix that. One other thing that came up during the discussion is that there are not a lot of fee waivers, or there are not of fees charged right now. I know many journalists, I've had many conversations with journalists, clients and not, who do not request records from certain public bodies because all they'll get is a big bill. And it's just not worth their time to even submit the request. So if this, I mean, I'm sort of arguing against my position, but if this waiver is added and it's mandatory, then there will be more requests from media. It will dramatically increase the volume of records requests, I think, which would be great. I think there should be more information that goes to the press, and I think the press is being stymied by the current fee structure. But also, I don't think we should ignore that effect. We should recognize that the reason we're doing this is because these fees are blocking the media from accessing information about our government.
Thank you very much. Mindy Lane, you also wanted to testify?
Hey, thank you for having me. I was just thinking over what Alan Kessler was saying, and I work at the Oregon Water Resources Department, and I'm thinking of Alan's examples where you could pool resources and have someone from another agency or the public records advocate come pour through our records for public records requests. I'm failing to think of a scenario where that would be feasible because our agency records are so specialized, especially when you're talking about going through emails. And then to his point about, Portland Police Bureau, I used to work in criminal justice for about 10 years. And even to be able to have access to read the police reports or read the data that's in that, you have to go through security clearance. You have to be qualified and cleared by the state to be able to review those records. So, I think it's a great idea. I can't think of a scenario where that would be feasible for my agency or for a police agency. And even, me working in public records, I could never walk into DEQ and respond to a public records request that they've received. Anyways, that's all I wanted to say. Thank you for your time.
Thank you. And Tyler and Steve both have their hands up, but I had a quick question, Mindy, if you're still here. Did she go? Mindy, I do have a quick question. You said that your emails are so specialized. Could you just elaborate a tiny bit? What do you mean by your emails are so specialized?
I misspoke. It's very watered down. I mean the content of the requests, what they're requesting. You'd have to know more about the agency or understand the language or the terminology to be able to review records and determine if they're responsive to that request.
Okay, thank you. Tyler?
Yes, I just wanted to say, there's two places, the state, right, to Mr. Kessler's point, you could offer sort of like a pooled manpower where you could actually borrow somebody. But barring that, and I know that we discussed trying to keep a fiscal off of this thing, and so we tossed this out pretty early, some of us being surprised by that. But, if there were some sort of state pooled resources, and I'm talking about funding, where the local body with that localized knowledge would be able to respond to them. But I actually think that would help because, one of our tests here in the expanded public interest test is that burden on other services performed. Well, if there was a pool of funding, that removes an argument from a government that they can't do this because of limited funding. So yeah, I think if we're talking about in partnership at all levels of government, if there was sort of a state fund that lived maybe in Todd's office that local governments could tap for reimbursement, or could tap proactively when they get a huge request and says, and the requester says, well, I can't pay it. Maybe there's something where you could apply without much administrative burden to this fund that covers that transparency, which is something that we all value.
Tyler, in my notes of points we need to go back to, this is on that proposal I put together a couple weeks ago. Not discussed in detail, but significant agreement. It's appropriate for the state to support public records management and release for local government bodies. I think because of, rightfully all you guys who work in the legislature lobbying understanding of the risks of fiscals, I think we had not, again, significantly discussed this, but kind of thought, well, we should at least put some language in there in this bill to say that this is appropriate and lay the groundwork for creating this kind of fund in the next session. That type of conversation was something that was definitely a point I felt we should go back to, along with the indigent and individual records. I did see Steve's hand up, but I don't know if it's still there. No, we're getting to the end here.
Yeah.
Go ahead.
I'll withdraw.
Okay. So the path seems pretty clear. Like I can see the steps that we need to take. 2 meetings doesn't, in fact, with the one being next week, doesn't feel like we can quite get there. But the steps as I see them are to move forward with Steve's proposed language. In the process of doing that, have anyone who would like to address specific wording in this come prepared with proposals before we entirely sign off on this way forward. Another piece that's important is to revisit many of the different things that we've talked about or come to close consensus on, or are in Todd's proposal, a whole checklist of like, what do we want to do with this? And after we have some general consensus on those things, then those would of course need to be put into plain language. Here's what we mean. And so that also takes some time. So, so question number 1, I guess, is can people meet on the week of the 21st? And I guess that's the first piece. And then, I can write up a little schedule of like, here's what we're going to do. Here's the points we're going to consider, add to it if there's other things you want to talk about, and have some real specific agendas for the next couple of meetings, which I know can be helpful for preparation. First question, can people meet on the 21st? If not, we could take the 14th and the 28th and then go back to the PRAC on the next. Okay, I'm seeing a thumbs down. I'm seeing, okay. So how many, do we have a quorum for the 21st? 1, Scott. 2, Steve. 3, Mark. Tyler, I can't see your hands. You can't, thumbs down. Michael, do you know if you can meet the 21st? That's a thumbs up. Okay, I think we have a quorum for the 21st. Mark and Todd, you want to jump in here on scheduling stuff?
Yeah, I'll be on the coast at a training. The schedule isn't set yet, so I don't know if I'll either be conducting the training or driving to or fro during that time yet.
Okay. Do you have any influence?
Really, it's the Oregon Code Officers Enforcement Association conference.
Okay.
So here's what I would like to say is, if Tyler can't make it, that feels important to me, but if what we're looking for is specific language beforehand, is that something you could provide to us for our consideration in writing in advance of that, Tyler?
Well, actually, I don't know if we could aim for that on the 14th, where we actually do have a meeting that year. Tyler, it's on our calendars already.
All right.
That one's already on our calendar. So if we could address the, proposed changes to the Steve's plain language on the 14th, and then open the discussion on other points, other outstanding points, and then finished ideally that discussion on the 21st and the 28th. That would be how I'd move forward. Mark, you have your hand up?
Yeah, I was just going to say, I don't know if I can get a satisfactory answer on the plain language question by the 14th. And my hope was that we could do that at the meeting by the 21st, because I do think I could have a reasonable response by that time. So having said that, I mean, I guess that the question becomes, is it the 14th or the 21st? Knowing that Tyler's not going to be able to be there, but knowing he'll be able to provide written response by the 21st, I would hope that we could shoot for the 21st with the plain language issue contained in Steve's draft. I might be able to get it to you beforehand, and would certainly endeavor to do so. But just to be safe, Madam Chair, I would say that the 21st is a reasonable deadline. Certainly could shoot for the 14th. I just don't have any expectation that I would necessarily have a satisfactory answer by that time.
Okay, so a couple things, we could just flip it and talk about what other things we want to make sure to include on the 20th. But there's also, nobody said we had to meet on the 21st. I mean, there is the 20th, there is the 19th. Are there other days that week that work for folks? You can just open up your microphone.
I was the only one who couldn't make the 21st. It's just because I'd be driving that day in Minnesota and making my way to an airport. I could meet any other day that week. I'll be in Minnesota, but I'm happy to call in or join in.
Would the 20th at this regular time period work for people?
I could do the 20th, but not until 3.
Okay, okay. I know that makes it tough for some other folks.
Can I just say that the idea of flipping the discussion might make some sense? I mean, I feel like we then are more likely to be in a place to put together a final product on that week of the 21st if we have sort of taken the week between to say, okay, well, what are we going to add to this language? Try and hammer that out. I still would, just because this is how my brain works, I doubt we'll have the language hammered out, but maybe we want our goal at the meeting next week to be, okay, Todd, now give us a separate document that does these other things. We'll come together on the 24th, first hammer out the first document, and hopefully just be able to put them together. But I don't know. Maybe there's a lot of if coming off of this plan.
There's always a lot of ifs, aren't there? So yeah, that seems to be make sense. But of that week, so is there a day and time that we can at least get the 7 of us who are here today to say we can meet? So the 21st had only 5 people, I think, unless the 20th you could meet at 3. Todd, does that work for you?
I hate to be the holdout, but I'll actually be headed to the coast that day, and I just don't know yet. I could try to hold off and leave after that, but I'm not sure, to tell you the truth. I guess I could also call in if I'm driving, but as I go through the mountains, I'd probably lose you.
You go down at 9 and have a walk on the beach while you're at the meeting.
I don't know. You ask my wife, kids, dog, everything else. It's
okay, and just I'm going to go one day backwards. I don't want to go too far back so that the meetings all to be stacked too close. But on the 19th, is that a possibility for people? Seeing some thumbs up, a wiggle.
I might be late. I could be there at like 2, but that's all right.
2 o'clock.
And I do have a conflict from noon to probably 2. I might be able to be a little bit more flexible and join at 1. But I'll make it work if it's that day.
Okay. You know what I'd like to do? I know probably does everybody hate doodle polls. I would like to put together a doodle poll with a few very specific date times on those days. Let me just check real quick. Can people meet in the morning on those days? I know, Steve, that's generally a tricky for you because the East Coast. Yeah, okay. So afternoons tend to be better. I think a mixed. Okay, let me put a doodle poll together on the time and day to meet that week of the week of the 21st. We will plan to meet that week. We'll spend I'll send out a list about what are the outstanding things that are the checklist that we'll try to address to put onto, what else do we want in this bill? And then we'll come back on the week of the 21st with anyone specific language changes to this, Steve's language around the core of shall and public interest. And we'll see where we get to. And the 28th, we may come back to a legislative subcommittee meeting, or we may be able to go back to the full PRAC. Does that sound okay?
Can somebody remind me when our meeting on the 28th is?
It's the 1 to 3, Todd.
1 to 3. Thank you.
I think, I'm not sure. Let me just.
That's
Yes,
correct.
1 to 3.
1 to 3, yeah. That's the,
Emily,
yeah.
thank you
Wait,
for your work getting us to where we are. And Steve and Todd, you guys both also deserve a lot of thanks for the work you put into this.
Yeah, 100% echo on Steve and Todd, all that writing you guys did, but and to everybody bringing your ideas and your frank concerns. Really appreciate it.
I agree with that, but I would want to point out the invite I have for the 28th from Todd is 2:30 to 4.
Really?
That's the invitation I have for the 28th.
Oh, I have one.
Scott, I'll resend it. I think that was the original one, and then because of these discussions and work, we changed it, but I'm sorry I didn't get to. I'll send you another one.
Okay.
Okay, cool. Okay, do you have a motion to adjourn?
I move to adjourn.
I'm sorry.
Wait, procedural question, because we did have a motion on the table that I think doesn't need to be on the table, so it needs to be withdrawn, and then I think we can procedurally go. I don't mean to be formal. I'm not what is it? Rules of where's my book?
Actually, you know what?
My Robert's rules of parliamentary procedure are not in front of me, but I cannot let this go. Please withdraw the motion and then we can adjourn.
Just to be following that, I don't think there was a motion. I think I said I sense a coalescing around this. Is this something we should do? But nobody actually ever made a motion.
Okay, forgive me.
To ask for one, but I don't think we even got.
I move to adjourn. I second the motion to adjourn.
All right, all in favor, say aye.
Aye.
Any opposed? Great. See y'all soon, and look for that doodle poll, please, and the checklist, and just a reminder on your comments on language. Thank you.
Bye, guys.